Good afternoon and welcome to the second of our 3 webinars in this new rural litigation series. My name is Stephanie Hepburn. I'm a solicitor in our Dispute Resolution Department, specialising in property litigation.
And I'm Emma DeSaley, a solicitor in our rural property team.
We have 3 webinars in this current series. I hope to roll out more in the future. The first webinar was on way leaves back in April, and a recording is available on Vimeo. The link should be on your screen there. And you can also find it on our website, www.shepwed.co.uk. Today's webinar will focus on criminal liability in the countryside, and the series will conclude in June with a webinar on private residential tenancies, current reform and the impact on rural rented properties. If you have any questions as we go along, please put them in the box on your screen there and we'll try and answer them at the end. Looking now at criminal liability in the countryside. At its broadest, this includes any crime occurring in a rural setting, but we're going to today narrow our focus to those areas we think will be of most interest to landowners and land managers. In particular, we're going to focus on the Wildlife and Natural Environment in Scotland Act 2011, also known as the WANE Act, but we'll also look briefly at some other issues we've dealt with for clients previously, like liability for animals and environmental crime. The WANE Act amended the Wildlife and Countryside Act 1981, and we'll also touch on that Act in relation to back colonies and development issues. To keep it interesting, we'll also use our fictional farmer, Archie Pickle, as an example, who we also used in the webinar's Way Leave webinar, to help illustrate the potential issues that what you can do if you encounter them. Emma's now going to briefly outline what the WANE Act does and its impact.
Thanks, Steph. The WANE Act was designed to update the law relating to the protection of the rural environment and is arguably one of the most substantial legislative changes affecting land management passed by the Scottish Parliament. It amended a number of previous statutes, including the Wildlife and Countryside Act 1981, the Protection of Badgers Act 1992, and the Deer Scotland Act 1996. The WANE Act came into force on 1 January 2012. So broadly, the Act covers 4 aspects of the natural environment: wildlife in general, deer, biodiversity, and sites of special scientific interest. The WANE Act updated the rules relating to poaching offences, controls of invasive non-native species, and the licensing system for protected species such as wild hares. It also amended the arrangements for deer management and deer stalking and strengthened protection for badgers. The change brought into effect by the Act that's really received the most attention to date is the concept of vicarious criminal liability. Some of you may be familiar with the concept of vicarious liability in a civil context, for example, where a landowner can be liable for negligence of his employees where it's caused a loss to a third party, but the WANE Act has brought in a criminal offence regarding the mistreatment of wild birds. Now, a landowner or manager may be liable for criminal acts done by his employees, agents or contractors who are under his management or control. The Crown Prosecution Service brings prosecution under the WANE Act, and there is also a dedicated wildlife crime liaison officer within each of the divisions on Police Scotland, and any wildlife crime can be reported directly to the relevant officer in your region. And it's now very clear as a result of this Act that landowners must now take a proactive role in the management of their lands if they are to escape the criminal vicarious liability provisions of the Act. Emma's going to touch briefly on what the new Act does and what it provides in relation to this new concept before I pick up on our farmer Archie Pickle story to help illustrate this and some of the potential steps landowners and managers should take to help avoid potential criminal liability. So Section 18A, subsections 1 to 2 of the Wildlife and Countryside Act 1981, as amended by the WANE Act, states that where a person, A, commits a relevant offence while acting as an employee or agent of a person, B, who has a legal right to kill or take a wild bird on or over that land, or manages or controls the exercise of any such right, B is also guilty of the offence and liable to be proceeded against and punished accordingly. The offence is therefore aimed at both the person committing the crime and the landowner who has rights for the management of the land in relation to the killing or taking of wild birds, the habitat of any birds, the presence of birds predators on the land, or the release of birds from captivity for shooting. This means that a landowner can be vicariously liable for an offence committed by their employee or agent, even where they have a legal right to kill wild game birds. It's worth noting that there are no equivalent vicarious criminal liability provisions in England and Wales at present, although this may soon change. Following the Law Commission's wildlife law consultation in England and Wales, the Environment Audit Committee have recommended that the UK Government evaluates the effect of introducing vicarious liability in Scotland and considers creating a similar offence in England and Wales.
Thanks, Emma. Let us now go back to Pickle Farm to find out what's happened since we've been away. As you may have guessed, the tranquility we left Pickle Farm with did not last. We came back to find that Archie has got a call out of the blue telling him a long-lost uncle has passed away and he's inherited a large estate in the Highlands. He drives up to survey his new land, and as soon as the formalities are completed, he renames it Pickle Estate. Ever entrepreneurial, Archie gets underway turning Pickle Estate into a successful rural business. While Archie's experience farming Pickle Farm and running the holiday lets business means he is in some of the financial side of his new business, he soon realises that he has a lot to learn about managing his new estate. He speaks to a solicitor and gets advice about any relevant legislation he must comply with, especially in regards to changes brought in by the WANE Act. He follows the lawyer's advice to the letter. He had a bad experience before with the whaleys and had to go to court and doesn't want to end up there again. And we'll pick up on the advice Archie's been given a bit later on. Archie appoints a new gamekeeper to manage Pickle Estate, Jimmy Jam. Gamekeeper Jam is taken on as an independent contractor. There is no employment contract entered into, and we'll come back to that issue in a second. Pickle Estate soon has a lot of bookings, including from very influential people, so Archie is keen to impress. There's only one problem. Gamekeeper Jam comes to him and says a lot of the new pheasants he has put down are being scared off by the estate by birds of prey. Archie is furious that the prospect of his best laid plan has been thwarted and goes to his trusty land agent Annie, who you also might remember from the last webinar. He also asks if he can solve the problem by trapping the birds of prey. And what advice might Annie give Archie?
Thanks, Steph. Annie tells Archie that this is firmly not allowed. Under Section 1 of the Wildlife and Countryside Act 1981, as amended by the WANE Act, it is an offence to intentionally or recklessly kill, injure or take any wild bird. Throughout this legislation, the definition of a wild bird is one that is of a species that is resident in or is a visitor to the European territory of any member state in a wild state. The birds of prey fall under this definition.
Archie accepts this. He didn't want to trap the birds anyway. He also thinks that his guests might appreciate seeing the birds of prey when they visit too, and realises that if it became public, the PR implications of trapping the birds could have been damaging to his business. Archie goes back to Pickle Estate to discuss with Gamekeeper Jam how they can best protect the pheasants without breaking the law. Annie soon receives another call from Archie. A dead trapped buzzard has been found on Pickle Farm, and Gamekeeper Jam has been arrested by the police. Archie wants to know what will happen to Gamekeeper Jam if it transpires he set the traps which killed the buzzard, and whether Archie himself might be liable. Annie refers Archie to his solicitor, who takes Archie through the WANE Act in more detail.
Archie's solicitor explains that Gamekeeper Jam is likely to be found guilty if he has committed one of the relevant offences in terms of the WANE Act. The three relevant offences are the killing, harassing, taking or disturbing of a wild bird or its nest, the setting of traps, poisons or the use of other prohibited methods for killing or taking, and the use of pesticides containing one or more prescribed ingredients. Attempts to commit such offences are also included. It's clear then, if it can be established that Gamekeeper Jam did set the traps, he will be found criminally liable. He may face up to 6 months in prison or a £5,000 fine, or both. Archie wants to know more about his own potential exposure to liability. He has heard about this new concept of criminal vicarious liability, where a landowner or manager may be liable for criminal acts committed by its employees, agents or contractors, who are under his management or control, but Archie is not sure what this means. He knows that he does not have an employment contract with Gamekeeper Jam. Jimmy Jam is self-employed. Does this mean Archie will escape vicarious liability? And what is his exposure if he is convicted? Will he go to prison? Steph, can you advise?
Well, looking firstly at the penalties imposed on landowners who are found to be vicariously liable, the maximum fine is £5,000 and up to 6 months in prison. However, that is only in the case of one offence being committed. It seems here that Gamekeeper Jam has only been accused of one offence, but it's worth bearing in mind that a gamekeeper is found guilty of more than one offence, e.g. in respect of more than one bird or one nest or egg, for example. These are seen as separate offences and they carry separate penalties. So the maximum £5,000 penalty applies to single offences only. Looking now at Archie's question as to whether he may escape vicarious liability because Gamekeeper Jam is not an employee. Any attempts by landowners to evade vicarious liability by hiring staff on a self-employed basis are struck at by the Act, which does apply to more than just employer-employee relationships. It's therefore not the case that Archie will escape liability just because Gamekeeper Jam is not an employee. It's enough that he is Archie's contractor, provided that he is giving a relevant service to Archie. These provisions could also apply to sport time and or farming tenants who are providing a service for the landowner, as well as less formal arrangements with an employment contract not been entered into.
Is Gamekeeper Jam providing a relevant service?
A relevant service is defined in the 1981 Act as amended by the WANE Act. A. If Gamekeeper Jam manages or controls any of the following: the operation or activity of killing or taking any wild birds on or over that land, the habitat of any such birds on the land, the presence on or over that land of predators of any such birds, the release of birds from captivity for the purpose of them being killed or taken on or over that land, and B, whether Gamekeeper Jam is providing the services by arrangement between him and Archie, or by arrangement with him as an employer or agent or any other person, C, is providing or securing the provision of a relevant service for B. These are questions of fact and difficult to challenge. On the basis that Jimmy Jam is engaged as a gamekeeper, he is clearly engaged in the services listed above, so Archie may be vicariously liable.
Can Archie only be charged once Gamekeeper Jam is convicted?
Well, whilst we would expect in most cases that proceedings against a landowner or employer would only follow if the employee or agent has been prosecuted, Section 18A, Subsection 4 of the Act provides that action may be taken against Archie whether or not proceedings have been taken against the Gamekeeper Jam. The reason for this really seems to be to catch landowner offenders and to use the threat of prosecution as a deterrent to discourage them from turning a blind eye to criminal acts that have been committed by their employees and contractors.
Archie thinks this is unfair. How, after all, could he stop Gamekeeper Jam from trapping the birds? Does he not have any defence? Steph, can you advise?
Well, there are defences open to Archie. He needs to be able to show both that he didn't know the offence was being committed by Gamekeeper Jam and that he took all reasonable steps and exercised all due diligence to prevent the offence from being committed.
Archie turns to his lawyer for further advice as to whether these defences might apply to him. Archie is relieved that he consulted his solicitor at the outset before opening Pickle Estate and knows that he followed all of the advice given to him.
Well, looking at the first defence, establishing if Archie knew the offence was being committed, it's a matter of fact, although the court may make reasonable inferences. Archie is adamant he had no knowledge of the traps being set by Gamekeeper Jam. He would never have authorised this. Looking at the second defence, Archie's lawyer reminds him of the advice he gave at the outset about the reasonable steps Archie should have taken and due diligence should have carried out to prevent the offence from being committed. The more precautions that are put in place by a landowner, the harder it will be for a guilty verdict to be brought against them. Unfortunately, there's no list in the Act of things that Archie must do, but his solicitor made a number of recommendations, both from a legal and practical perspective. Bodies such as Scottish Land and Estates have also produced good practice guides and recommendations for due diligence that landowners should refer to.
Steph, what advice did Archie's solicitor give him at the outset?
Okay, first at the legal steps that the solicitor recommended. Archie should ensure that all contracts, including those with employees and independent contractors, as well as leases, include the requirement to comply with all statutory obligations and refrain from any illegal activities. Reference to the WANE Act should be made, and also the 1981 Act, which says that no crimes under these acts are to be committed. It may also be appropriate to list other legislation that could be relevant that should also be complied with. Looking at practical steps then, Archie should obtain full and proper references before engaging employees and contractors who are to have a responsibility for wildlife. He should also issue clear written instructions on the law and illegal activities to all employees, agents and contractors. There should be a clear division of responsibility and process in place by which Archie is to be kept informed as to what's happening on his land. He should look at whether there are particular activities he wants to be informed of before they occur. He should also carry out risk assessments, provide best practice guidelines and provide regular updates and training on wildlife crime, including about legal responsibilities. Archie should be kept informed of what's happening. A process of independent annual reviews and spot checks should be set up to prevent any offences from being committed. Any systems put in place to prevent wildlife crime should be regularly reviewed to check they still work and are being adhered to. If Archie becomes aware that a breach has occurred, appropriate action should be taken immediately. If legal traps are to be laid for different purposes, there needs to be evidence in place that the traps were laid with taking wild birds into account. Archie should also keep and maintain a pesticide register and supervise pesticide use.
Assuming Archie has taken all of these steps, what are Archie's chances of being able to rely on this two-pronged defence?
Well, whether it will work in practice really depends on proper planning on the part of the landowner or manager. It's worth considering that the legislation refers to all reasonable steps and not just reasonable steps. Until there's more case law, and we'll come on to the Glasserton case in a second, it's difficult to predict how a court will interpret all reasonable steps. I think what can be said is that it's an objective test in what is reasonable as a matter for the courts to decide. The question is one of fact and degree in the particular circumstances of the case at the time. All reasonable steps in our view is a difficult practical hurdle to overcome, and the tips we mentioned a second ago are not in any way meant to be exhaustive. There is really just that, hints and tips. The due diligence defence does appear in other statutes that create criminal vicarious liability offences, for example licensing legislation, and it might be cases coming out of those may also assist in assessing how the courts might interpret the defences in the wildlife crime legislation. As we'll see when we discuss the Glasserton case, ignorance of the law is not a defence, and half-hearted or token attempts at compliance will not work either. It is important to keep a paper trail, and that can't be emphasised enough. And it's also important that landowners are aware of potential risks to them in failing to take reasonable steps to prevent wildlife crime from occurring. Doing nothing is not an option. A failure to plan could be fatal.
Although not applicable to Archie's situation, where it is clear Gamekeeper Jam is providing a relevant service, it is worth noting that vicarious liability is not necessarily a foregone conclusion where someone is an employee or agent. Is it possible to establish that someone with a contract of employment is, in fact, not actually acting as an employee and thus helping the landowner escape vicarious liability?
Well, yes, as Emma said, the fact that someone's an employee does not automatically mean the employer will be vicariously liable if they commit a crime. If the person who commits the crime is an employee who has acted out of the scope of their employment, the landowner may escape vicarious liability. For example, if the employee has gone off on a frolic of his own for his own benefit and has acted in such a way the landowner would never have authorised, this may go to show they are out of the scope of their employment and thus help the landowner avoid vicarious liability. This is really where having clear provisions in the employment contract is important. If it's clear from the employment contract that the employee is acting beyond the scope of his employment by committing the crime, as implemented in practice by the landowner, this may go some way to establishing the landowner cannot be vicariously liable.
What about circumstances where there is no employment contract and the person who committed the act is not providing a relevant service? Does this mean the landowner can escape vicarious liability automatically?
Well, unfortunately not. Just because someone's not an employee doesn't mean that there's no vicarious liability on the part of the landowner. It already begs the question as to what is an employee. Can someone be employed in the absence of an employment contract? And the answer to that is possibly yes. It all comes down to the question of control. If there's not an employment contract in place, it's fair to say the CPS will be looking to establish the person committing the crime is actually acting in some capacity akin to employment so as to be able to go after the landowner or manager. Does the landowner control how that person commits the job? Does the landlord provide the equipment required for the job? How is the individual paid? These are all questions that go to the heart of whether someone is akin to an employee, and are things the landowner should be thinking about when it engages an agent or independent contractor.
Thankfully for us and the future of this webinar series, Archie is found to have taken all reasonable steps and executed all possible due diligence to prevent the crime being committed. His contract with Gamekeeper Jam, whilst not an employment contract, clearly stated that there was to be no breach of the wildlife crime legislation, and Archie had arranged for Gamekeeper Jam to have training on how to avoid committing a wildlife crime and his legal responsibilities. Archie is relieved and is glad he followed the advice he was given at the outset. It has made him wary, though, about his responsibilities both on Pickle Farm and Pickle Estate. He asked Annie whether there are any other issues he should be aware of, whether civil or criminal. Before considering these, we thought it would be helpful to consider the few criminal convictions that have come out of the WANE Act so far, and Steph is going to touch on these.
Well, as you might be aware, the first conviction under the WANE Act came from Glastonbury Estate in Whitshorn. In that case, a gamekeeper was arrested following an investigation into the death of a buzzard on the estate in December 2012. He was fined £4,500 for poisoning the buzzard and possessing illegal pesticides following a forensic analysis into the cause of death of the buzzard. The Glastonbury case also saw the first successive conviction following the introduction of vicarious criminal liability under the WANE Act. In December 2014, the landowner pled guilty to being vicariously liable for the gamekeeper's crimes and was ordered to pay a fine of around £600. The fine was said to reflect the landowner's previous good record and his guilty plea. Now, it might not be a high price to pay financially in practice, but reports in the press did suggest the true cost in the Glastonbury case came in a hefty reduction in subsidies as a result of the conviction, we think at around £66,000. And the shoot on the estate also closed down, which also has financial implications as well. In that case, there was no evidence, as far as we're aware, that the landowner had told the gamekeeper to kill the buzzards, nor that the landowner even knew the practice was going on. I think what this shows is that the WANE Act does place a proactive responsibility on landowners to prevent the persecution of wild birds on their land, and ignorance alone will not stop a conviction.
So far, there has only been one further case where a landowner has been found vicariously liable for the actions of an employee. This concerned the use of an illegal leg-hold trap which injured a buzzard. The employer, who leased part of the estate for his shooting business, employed a gamekeeper with responsibility for pest control. The gamekeeper set the traps and was sentenced to a community payback order after pleading guilty. In this case, the employer received a £3,200 fine. This shows a possible trend by the courts to demand higher levels of diligence from landowners and employers.
A case to keep a close eye on is an appeal against a conviction by William Dick, a gamekeeper at Newlands Estate in Dumfriesshire. In this case, the gamekeeper had been observed striking a buzzard with rocks and then stamping on the bird. In September last year, he was found guilty and given a £2,000 fine. The appeal was due to take place on 13th of May this year after being postponed in April, but we haven't yet heard the outcome. One person who followed this case closely is Mr Dick's employer at Newlands Estate, who is charged to be vicariously liable for these actions. Although an employer, as I said, can be charged regardless of whether or not the employee is also convicted, in this case the landowner's case has been postponed until the gamekeeper's appeal has been heard.
The two cases do show that, as Steph touched upon earlier, there is still a degree of uncertainty as to how the courts will approach cases brought under the new provisions. Some commentators see vicarious liability as the ultimate enforcement tool to stamp out persecution of wild animals, but others do see it as an unnecessary burden on landowners. It's not just landowners, managers and gamekeepers also have responsibilities, but until we see some more cases coming through the courts, it's difficult to predict the approach that the courts will take. The key message seems to be prepared. It's also worth noting that the Wildlife Crime Penalties Review has recommended an increase to the maximum fine for vicarious liability to £40,000, with a maximum prison term of 12 months. We do not yet know if this will come into force.
Going back to Archie Pickle, who is now wondering if there are any other things she should be thinking about as a landowner, and I'm reading through a few of these.
So Archie has noticed there are badgers on Pickle Estate. The Protection of Badgers Act 1992 has long meant that it is an offence, except under certain circumstances, such as where a badger is already seriously injured or where specifically authorised for scientific reasons, to willfully kill, injure or capture a badger or attempt to do any of these things. Even where killing a badger is permitted, there are strict rules governing how it can be done. It is also an offence to be in possession of a badger killed in contravention of the Act. Now, however, in a similar vein to the change of law relating to wild birds, the WANE Act has introduced a new offence of knowingly causing or permitting any of the two offences outlined above to be committed. While not as strong as the protection of wild birds, this marks a tightening up of the law, and landowners or business managers will find it harder to hide behind the conduct of their employees, something for Archie to bear in mind.
Archie also tells Annie the shooting trips at Pickle Estate are proving very popular, and he's thinking about converting some old stable buildings on the estate into more accommodation for guests. Annie knows this could be more problematic, as the stables have been derelict for a number of years and may have bats roosting in the building. Annie tells Archie before the work is to be carried out, a bat survey should be conducted. Emma, can you tell us more about this?
The reason for this is that bats are specially protected under the Wildlife and Countryside Act 1981 and the Conservation Natural Habitats Regulations 1994. It is an offence to kill, injure, capture, disturb or harass a bat under this legislation. In addition, because bats tend to come back to the same roost year after year, it is also an offence to damage, destroy or obstruct a bat roost. This means that the roosts are protected even when no bats are present. Carrying out work on buildings that house or house bats can therefore be deemed an offence unless the correct procedure is followed.
What does this mean? What will actually have to do in practice?
Licences can be obtained for certain purposes to permit actions which might otherwise be an offence in relation to bats. If bats are likely to be found in a site proposed for development, for instance in a building to be modified or demolished, or in trees that may need to be felled, then it is strongly recommended by SNH that a bat survey is undertaken. A bat survey should be carried out by a surveyor holding a current bat conservation roost licence. A list of surveyors holding these can be found online, and SNH have detailed guidance on their website. This licence is required in order to handle and inspect the bat roosts. Archie does not hold such a licence, so he should avoid any contact with the roosts or the bats, as this would be an offence. The survey will outline if bats or evidence of bat roosting is found in the stable buildings and will provide helpful information that Archie can then use to apply for a licence from the Species Licensing Team of the Landscape and Habitats Division at Scottish Natural Heritage before any work begins. Applications for this licence to start work will be awarded where the reason why the works are necessary is clearly stated, there is no other satisfactory solution, both in terms of why the work needs to be carried out and that there is no option other than to disturb the bats, and reasons must be given why the proposed work would not be detrimental to the maintenance of the population of bats concerned. A mitigation programme should be developed in consultation with a recognised expert and SNH and submitted with the application. In practical terms, the Species Licensing Team recommend that the application is submitted at least 6 to 8 weeks before work is due to commence.
Well, thanks, Emma. Knowing this information in advance will help Archie to properly plan any renovations to stable buildings and prevent them from inadvertently committing an offence. A few years pass and things in Pickle Farm Pickle Estate are going well. However, Archie's new gamekeeper, Jamie, has reported an issue that parrots are coming onto Pickle Estate from the neighbouring estate and causing damage. The gamekeeper wants to know how to deal with these, and again, Archie asks Annie for advice.
So Annie advises that as these birds, and remember we're using a bit of artistic licence here, are not a native Scottish species, they are not afforded any special protection by wildlife law and are regarded as a pet like any other. As a result, they are considered the property of their owner, unlike wild birds, and so taking or injuring the birds infringe the owner's property rights. On the other hand, the owner of the birds was under a duty to control their pets so that nuisance or damage is not caused by the birds. Archie goes to speak to the neighbouring owner Angus and asks him to control his birds. Angus refuses and says they are nothing to do with him anyway. So how can Archie deal with this? Annie advises him to contact the SSPCA to come and remove the birds. Archie does so and the birds are removed to a new home. Archie also advises Police Scotland that he has taken this action in relation to the birds who are considered lost or abandoned property as Angus has not claimed them. Of course, there are many other factors for landowners to be aware of which we have not touched on. We don't have time to consider these in detail today, but we thought it might be helpful to briefly outline some examples of criminal and civil cases we have been involved in. If any of these topics would be useful for an upcoming webinar, then please do let us know.
Well, one issue to think about is sheep worrying on neighbouring farms by a landowner's dogs. Archie often spends his free time walking his spaniel Tavish on Pickle estate and neighbouring properties. To avoid Tavish worrying livestock, he tries to keep to clear paths and avoid areas where he knows livestock are present. However, although well trained, Tavish sometimes runs off some distance from Archie, who is concerned. Emma, can you tell us what Archie can do?
So sheep worrying is becoming an increasingly difficult issue for many livestock farmers, and Archie should ensure he prevents Tavish from harming livestock. Archie should comply with the Scottish Outdoor Access Code and the information given in that for dog walkers. The code gives Archie some guidelines he should follow when walking Tavish. He should not take Tavish into a field where there are young animals and take an alternative route through neighbouring land or adjacent land. Try to avoid walking through fields with cattle or horses in them, but if this is unavoidable, he should keep Tavish on a short lead or under close control, using a lead less than 2 metres in length and ideally at his heel, and stay as far away as possible from the animals. When crossing a field with sheep, he should keep Tavish on a short lead or under close control and stay a distance away from the sheep. Although Archie is exercising his access rights under the Land Reform Scotland Act 2003, these do not allow him to be on land with a dog which is not under control.
Well, what if Archie doesn't comply and Tavish becomes out of control? What would happen then?
Well, if Archie doesn't comply with his responsibilities, then under the Dogs Protection of Livestock Act 1953, where Archie allows Tavish to worry livestock on agricultural land, he is guilty of a criminal offence under the Act, with a fine of up to £1,000, and Tavish could be seized by the police. The 1953 Act defines sheep worrying as including attacking livestock, chasing them in a way that may reasonably be expected to cause injury or suffering, and for females, abortion or loss of produce, or the dog being at large, i.e. not on a lead or under close control, in a field or enclosure in which there are sheep. There are also certain defences under the 1953 Act, including that the offence cannot apply to a dog owned by the sheep keeper or the owner of the field or a person authorised by either of those, and there are other defences as well under the 1953 Act. Under the Animals Scotland Act 1987, Archie could also be liable for civil damages for injury or damage caused, and the Act allows a landowner to take immediate action to protect livestock. This does not necessarily permit shooting of the dog, which is always a last resort, and the landowner must also have a lawful excuse for taking this action, and the police should always be called even if immediate action has to be taken before they arrive. So Steph, what other things should Archie be aware of?
Just a few examples on the screen there are some cases that we've been involved in over the last few years. Let's quickly run through some of these. Archie has a number of ducks and geese on his estate. We had a case where ducks and geese from a neighbouring estate were coming onto our client's land, and smells from the animals were putting a visitor to our client's castle. The claim was a civil action and nuisance, was eventually settled out of court. Probably quite unique circumstances, there's something for Archie to bear in mind. Shooting over a neighbour's estate, Archie needs to make sure any shooting on his land remains on his land and no shots are fired over a neighbour's land. We had a case where this happened, which we successfully settled by threatening to interdict a neighbour from shooting over our land. Liability for flooding. In our case, we had on one of the islands a nuisance claim against a neighbouring dam operator for failing to operate the dam in such a way that minimised risk of flooding to our client's land. Again, if Archie's neighbours have dams of Maryland which is causing flooding to his estate, something they can bear in mind. In nitrates, Archie should also ensure he manages his farm and estate in a way which manages environmental risk and to avoid or minimise any runoff or leaching of nitrate to surface or groundwater. Occupier's liability. A big issue for landowners is that they are liable as the occupier of the land for negligent acts of their employees, agents and contractors. It's separate to vicarious liability. It often crops up in personal injury context, where an employee or member of the public has been injured by someone employed by the estate who's acted negligently, who won't have any money to pay any award of damages, so the injured person sues the landowner as the occupier. We've had a number of these cases from minor injuries to fatal claims, but unfortunately will be a whole other webinar topic in its own. For Archie though, he needs to be aware of potential exposure to liability as the occupier of Pickle estate and take steps to minimise his risk where possible.
And finally, encroachment. Another issue we often see litigated is boundary disputes, encroachment and disputes regarding access rights. If it would be helpful to explore these in more detail in a future webinar, then please let us know.
I hope that's been a useful run-through of some of the issues involved in criminal liability that might arise from a landowner's perspective. We've also touched very briefly on civil liability. Of course, there may well be situations where you need further help from an expert, be it a land agent, surveyor or lawyer, but hopefully the webinar has helped you to identify when those might be.
The key piece of advice in relation to vicarious liability under the WANE Act is to make sure that any employees who may be in a position to commit an offence have had the law clearly explained to them, and processes are in place to ensure no crime is committed. You should also record what these processes are so that you can show a third party you have done all you can. This advice also applies to other areas too. Even if you are not aware of a statute directly outlawing what you intend to do, if you, your employees or your animals are doing anything that might harm neighbouring properties or the environment, then you need to make sure you are doing everything you can to prevent it. As our discussion of the WANE Act also shows, if you're unsure as to whether something might constitute an offence, you should seek advice.
Thanks, Emma. That's pretty much us running out of time. If anyone has any questions, please just get in touch. Either myself or Emma will be happy to answer any of your questions in relation to this or any other topic that you might want to discuss. As I mentioned earlier, the next webinar is on private residential tenancies on 22nd of June, and hopefully as many of you as possible can make it along to that. Thank you very much.
Thank you.